my understanding of what I am tasked with doing is to give you some context for the case, the Hashmi case, to put that in a broader perspective that makes clear its position within counterterrorism policy more generally. And so what I hope to do is to do that in two different ways. One is to tell you a little bit about the work of the Brennan Center on national security issues, which may give you a sense of some of the other cases that are emerging and coming up in the courts right now, although not criminal cases, as you'll see. And the second is to paint a picture of what or how the Hashmi case fits into a set of public policies that the government has adopted since 9/11 that are focused on preventive prosecutions and investigations. So I'll give you a set of things that the case links into, or a set of larger policies that I hope allows you to understand it as part of a broader trend that is happening in counterterrorism policy. So first, let me tell you a little bit about the Brennan Center's work. And we, unlike Sean, I and my colleague at the Brennan Center, who are litigators, don't represent people in criminal cases. We represent people who are detained. One of our clients is detained here in the United States, and the other two clients are detained overseas. But all of them are detained without any form of trial. They have never been given the opportunity to come into a court, to go before somebody who is independent and say, I'm being held for the wrong reasons. And they're all accused of very serious terrorism-related offenses, but they've never been actually charged criminally or given the chance to defend themselves. So one of our clients is a man called Ali Al-Mari, who is a Qatari national who has been detained in a military brig in South Carolina since 2004. And he is, in 2004, he was designated as an enemy combatant by the president. And for the first roughly 18 months after his detention, when he had been moved to the South Carolina Naval Brig, he was held in solitary confinement. He was denied many basics. So he was denied a Quran, he was denied various forms of clothing, he was subjected to environmental manipulation, temperature and lighting changes that put stress on his psychology, obviously under the circumstances of solitary confinement. He was even his toilet paper was rationed as a way of subjecting him to psychological pressures. We have challenged his military detention in federal court, and that case has been in the court since 2004. It takes a very long time for these cases to percolate up, and at each level you have to challenge it. In each of these cases you have to challenge it first in a district court, then a court of appeals, and then it can go even further. And in Al-Mari's case, where we stand is that we recently won a victory in the Court of Appeals, called the Fourth Circuit Court of Appeals, which issued what we think is an important ruling, holding that the government doesn't have the power to seize people within the United States and subject them to military detention. That ruling now is on appeal, and we'll see whether it stands up in various ways. So the second principal case that we work on involves two US citizens who were both seized in Iraq. They were seized in 2004 and 2005. They're both accused of very serious criminal offenses. Neither of them have been given access to an opportunity to show that the government's allegations against them are wrong. At least one of our clients, when he was picked up, was beaten fairly severely. The photos that we have from after his seizure show show concussions and bruising across most of his body. And apparently there is evidence that the government hasn't released to us that he was also subjected to electric shocks. In those cases, we also filed suit, arguing that the government needed to come into a court and show the court evidence, to produce the evidence of why our clients are lawfully detained. And the government has so far refused to do that. The government's position in these two cases, they're called Omar and Manaf, The government's position is that because the detention is occurring in Iraq, the United States is not responsible for it, even though it is a US official who literally stands at the door of our client's cells and holds the key. The government actually argues that because the operation in Iraq has a United Nations sanction, that the United States is not legally responsible for their detention, and therefore we cannot challenge in a federal court our client's detention. And so in that case, in these two cases, there was a relatively complex set of litigation in the lower courts that ended up in a preliminary injunction. We basically got an order from a court barring our client's transfer to any other authority, because the government said that they were going to transfer our clients to Iraqi authority, and we basically knew that they would be tortured and killed in Iraqi authority. And so these cases are now on appeal to the United States Supreme Court. And so we actually just filed our brief in the Supreme Court on Thursday, and it's available on our website, www.brennancenter.org. So you could go and look at, if you wanted to see sort of what the case is about and what the legal arguments are, it's on the website. And then the Supreme Court will hear the case, and a colleague of mine who teaches at Northwestern Law School is arguing the case on March the 25th. So that's the sort of case that that I work on. But I also do a lot of public policy work. So for example, the book that was mentioned, Unchecked and Unbalanced, which is a book about the legal theories that the government has used to justify torture, wiretapping, detention, and extraordinary rendition. Basically, it's a book arguing that those legal theories are deeply flawed and essentially wrong, and if they were exposed, they would be shown to be wrong. We do a lot of work here in the city with other with Muslim groups on, for example, the NYPD's counterterrorism policies, and we do a good amount of work with Congress on policies like the removal of habeas corpus for the Guantanamo detainees, which is again the power to challenge detention in federal court. So what I hope that brief description gives you is a sense of sort of a larger shadow of cases and problems that are around the criminal problems that arise in the Hashmi case. There is a broader and perhaps more ominous penumbra of military-related policies, and these are the policies that I end up dealing with in my daily work. Military-related policies that extend, that I think it's fair to say originated in places like Afghanistan and Iraq, but are gradually creeping their way closer and closer back to the United States, where the Al-Mari case, which is the case I started off by describing, is an example of that, the military policies coming home to the United States. So that's sort of one way of thinking about the broader context of these cases, that the criminal cases are actually only one part of a larger policy that has this military component. So that's one sort of conception, way of thinking about these cases, or way of thinking about and understanding the significance of the Hashmi case. Another way is by thinking of it in thinking about thinking about it from the perspective of the government, and thinking about what the government is these days trying to do